Good morning and welcome to today's webinar, Exempt and Non-Exempt Employees, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Michelle Wilcox and I will be your moderator today. I will be moderating questions you may have during the session, but before we open up the session, let's review a couple of key items. All the webinar materials we discussed can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. We do not control the audio, your devices control the audio. So if you have audio difficulties, try adjusting the volume settings on your device. If a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you're using a tablet, you may need to tap on the screen for the options bar to appear and then select the appropriate option. We may not respond immediately, but we will work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, and we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenters will be answering questions at the end. And lastly, we have a number of upcoming webinars covering a variety of topics, including those listed at the Heffernan webinar website. With that being said, let's begin today's webinar, Exempt and Non-Exempt Employees. Our presenter today is Nicole Osborne. Nicole holds a master's in business administration, is a certified senior professional in human resources, and is the owner of Synergize HR Consulting. As a private consultant, she works with the small to mid-sized businesses and local government as a strategic partner in matters of performance management, training and development, lead management, Americans with Disabilities Act, interactive process, equal employment opportunities, and safety. In addition, she works with individuals as a job coach and expert resume writer. Throughout her career, she has provided strategic direction through leadership and championed the development of initiatives to recognize and retain top talent. Thank you for being with us, Nicole, today, and I'm going to turn it over to you.
Fantastic. Thank you so much, Michelle. It's a pleasure being here today with all of you to talk about exempt versus non-exempt employees. This is a common question that comes up quite a bit when trying to develop job descriptions and put your employees into appropriate pay ranges. So hopefully that you have a lot of great questions that you bring here today. I'll be happy to answer any questions as they come up. So feel free to type your questions in the chat box and we will get to them as soon as possible. So we do have a disclaimer here today that the information presented is general in nature and is intended to present an overview of employment practices. The written and verbal contents of this presentation are not intended to constitute consulting and/or advice, and no client relationship is established between myself and the attendees. So I'd just like to get started here by asking you a quick pop quiz question. I'd like to know, are salaried and exempt employees, are they basically the same thing? True or false?
I've just launched the poll, Nicole. We'll wait here for a few minutes to get at least kind of answers. It looks like 75% say false and 25% say true.
Okay, awesome. So 75% of you would be correct. The answer is false, and we will discuss why in this presentation. So if you answered true, stay tuned for the answer, more information about why that is a false thing. Okay, so today's objectives are we're going to go over some of the definitions of the exempt and non-exempt. We're going to talk about the penalties associated with misclassifying your employees. and what the exemptions are so that you can better understand what you can use to exempt your employees from overtime. So the definition of exempt, let's talk about that first. All right, so some employees are exempt from requirements of the Federal Labor Standards Act, or FLSA, such as overtime pay, and are typically paid on a salary basis. Usually these people are professionals or executives, administrators, or they meet certain criteria specified by the FLSA or also state labor laws. For instance, California does have some more stringent laws than FLSA that you need to be aware of if you're a practitioner or you're managing people in California. So exempt employees are exempt from overtime pay and minimum wage provisions. They're classified as one of those specific exemptions that we'll be discussing, and they're typically paid on a salary basis and generally have higher level responsibilities or specialized knowledge. Non-exempt employees refer to employees who are entitled to overtime pay. This is going to be your majority of people in your organization. They're not exempt from the provisions of the FLSA in the United States. So usually they are paid and eligible for anything that is over 40 hours in a work week or 8 hours in a day. Now there are some caveats to that. If you are in an alternative work arrangement codified by the state, or if you have a bargaining environment for union and you've agreed to terms outside of that, that's different. But for the large part, we're talking about over 8 hours a day and 40 hours in a work week is your overtime. Non-exempt employees are subject to specific regulations regarding minimum wage, record keeping, and then other labor standards. So non-exempt employees are entitled to overtime pay, and they receive at least the federal minimum wage for all hours worked. They are typically your hourly workers, blue collar workers, your line level people, lower level positions. So they have legal protections such as ensuring that they receive proper compensation for their work hours and additional pay for overtime. So let's give you some examples of exempt positions. So an exempt person could be a financial consultant working for a firm. It could be an accounting manager or an HR manager. Ones that are not typically exempt are your frontline supervisors, your office manager, or your executive or administrative assistant. Those are some of the roles that sometimes do get misclassified. Sometimes organizations put a lot of pressure on HR professionals to classify something as exempt because the salary level test is met. But there are two tests that have to be met. Salary is only one. And so if the responsibilities of that position or that job description isn't in alignment with an exempt position, you could end up with a complaint, and you may be having to pay back pay for all overtime that was worked. So I just want to go over some of these cases. These are specific ones that were called out because of their impact to the organizations. AT&T, this was filed in federal court in Connecticut. It was a certified class action, and California and Georgia also granted conditional certification of FLSA collective actions. So this claim was brought by two field managers on behalf of all field managers. And these are really common. Attorneys love picking up anything that they can do class action because they make more money. AT&T had a multi-tiered management structure with at least 7 levels. So it was a very complex organization. The field managers were at the very bottom of the pyramid, acting as low-level functionaries whose essential role was to relay information back and forth between technicians and management. They had a minimal role in supervision and no authority to make employment-related decisions. So they didn't do hiring, firing, discipline, things like that. They were tightly controlled by the company policy, and their supervisors did not let them exercise discretion or independent judgment to matters of significance. So they had a rule book, they had to follow it, and they didn't go outside those lines. They were working 50 to 70 hours per week, and often had to work from home to keep up with all the tasks. Additionally, they had to participate in a rotation to remain on call for 24 hours a day. So this case was settled for $28 million in class and collective actions for failure to pay their first level managers overtime. So again, this is an example, a really significant one of where these employees were misclassified, and because someone complained and an attorney was able to pick that up for all represented employees, it was a very large settlement. Another one was City Gear. City Gear was a rapidly expanding clothing retailer with more than 100 stores throughout the South and Midwest. In 2011, it employed approximately 500 workers and had revenues of $64.5 million. The lawsuit alleges that it was garnering record profits on the backs of the workers in this case. So on October 15, 2013, City Gear agreed to pay $1.9 million to settle. That's a lot for a 500 employee organization. So just think of the impact if that was your organization and unbudgeted, you had $1.9 million assigned to you. So that's something to be mindful of. Another one is Alaska Communications System Group. It was one of Alaska's largest communications companies, and the suit alleged that Alaska Communications Systems Group failed to pay its sales and marketing employees overtime pay as required under the federal and state laws. It also alleged that the company forced its sales and marketing employees to falsify their timesheets by not allowing them to record their overtime hours. The lead plaintiff started as a market analyst and then moved into a sales position during her 8 years of employment. The company classified her as an exempt employee and therefore not entitled to overtime. She averaged more than 60 hours per week. So that was a big one. And, you know, a lot of times disgruntled employees will be your squeaky wheel that gets your attention on these matters. So if you're not proactively auditing and an employee gets upset, you better believe that they're going to be reading the law and talking to attorneys. So most commonly, an employer will label an employee as a manager or a supervisor, pay them a salary, and then claim that they are exempt under the executive exemption. In rare instances, the employee's salary may not meet the minimum required. Usually it does. I think that most organizations are smart enough to know that they have to meet that salary test. But more often, the employee's duties do not meet the exemption requirements. Usually they lack the necessary managerial and supervisory authority required by the exemption. It's also important to remember that merely being paid a salary or being labeled a manager does not determine your exempt status. Only your job duties do. So you can't give someone a fancy title and continue to work them as an office assistant and then expect that you're going to pass both sides of that test. So the title alone does not make you exempt. All employees are non-exempt unless you can prove otherwise. That is the best practice. So you always start with that premise that this is going to be an hourly position. And then if you run it through the tests and or consult with your HR practitioners or an attorney, then you can determine if it meets that salary and the duties test. So if you currently are inheriting an HR department or a team where you have things that are classified and you weren't part of those decisions, you may want to consider an audit. And if you are going to consider an audit, I would greatly recommend that you get an attorney and place that audit under privilege protection of the attorney. That way, if you find things that they're not discoverable, and if you have an employee that files it in a class action results, that audit will stay under attorney-client privilege. Okay, so the first test that you have to meet is the salary test. So the minimum salary is a calculation. It's 2 times your state's minimum wage times 2,080 hours, which is the number of hours that an hourly person would work in a year. That would give you your minimum annual salary. That is a full-time equivalent position working 40 hours a week. Okay, so the salary test is outlined by the Fair Labor Standards Act in the United States as one of the criteria to use to determine whether an employee is exempt or non-exempt from receiving overtime pay. It establishes a minimum salary threshold that employees must meet to qualify for exemption from overtime pay. Employees must be paid a salary that meets or exceeds that specific threshold in your state in order to be classified as exempt from overtime pay. And then the threshold is set by the Department of Labor and is subject to periodic updates. So that means every year you have to reassess this, because as minimum wages go up and as things change, you have to be able to change with it. So one of the things with the salary test too is that proration is not allowed. The minimum must be met regardless of the hours worked. So that means you can't ding somebody if they have to be out of the office for a doctor visit or things like that. So you can't dock their pay unless certain conditions are met, and it gets very complicated. So the rule of thumb is just to leave their salary alone and think of it as an annual salary that's just being paid over time. It's like you're making installment payments on your salaried employee. So if you're using the minimum salary, there can be no unpaid time off. So that means if they are at the minimum for your state, twice of that minimum wage, you can't dock their pay at all. Now, if they're a little bit higher, there are some different caveats to do with that. Okay, so the big duties test is the discretion and judgment of the position. Those are your key factors that play a role in determining whether an employee is exempt or non-exempt under the FLSA in the United States. These factors are part of the duties test used to assess whether an employee qualifies for an exemption from overtime pay. So under the FLSA, employees who exercise a significant amount of discretion and independent judgment in the job duties may be classified as exempt employees. This exemption is typically known as the white-collar exemption and applies to certain categories of employees, including executive, administrative, and professional employees. To meet the exemption criteria based on discretion and judgment, an employee's work must involve performing duties that require the use of independent judgment and discretion in matters of significance. This may include making important decisions about the company's operations, policies, or personnel, as well as exercising authority and influence over the organization or its customers. It is important to note that the FLSA does not provide an exact definition of discretion and judgment. This is a subjective thing. That's why it's important to audit these things and make sure that you're classified appropriately. The interpretation of these terms may vary depending on the specific circumstances of the job and the industry. In practice, courts and the Department of Labor consider various factors such as the employee's level of decision-making authority, freedom from direct supervision, and the impact of their decisions on the organization.
Nicole, I'm sorry to interrupt. Somebody's asking, what if their employee is vaccinated?
I'm sorry, you cut out a little bit. Could you repeat?
I'm sorry. What if an employee is back from leave, an exempt employee, and their schedule is accommodated to only work 3 days of the week? Can we have them use PTO for the other 2 days or unpaid off?
Well, it depends on several factors. It depends on the policies of your organization, and it depends on what salary level they're at. If they're at that bare minimum salary of 2 times the minimum, you won't be able to. If they're higher, you may be able to, but you're going to want to consult with either an HR professional or an attorney to get specific guidance with that situation.
Thank you. Thank you.
You're welcome. Okay, so working managers. What comes to mind for this is, again, those field technicians. Working managers are usually non-exempt. They manage only a few employees, and then they spend over 50% of their time doing the same work as employees. And then a lot of times they're shared responsibility rather than directing employees. So these could be assistant managers or lead workers or something like that. So for instance, in one organization, There was 2 assistant security managers. They were both sharing in the duties of what a manager function would be in absence of a manager while the recruitment process was going on. But even though they were doing some of those managers' duties, they weren't going to meet that test because over 50% of the time was doing the same work as their security officers, which was patrolling and doing field reports and safety inspections and things like that. So be very careful with anyone that is doing the same work but steps up a small amount to cover in a lead or supervisory capacity. They're usually going to be non-exempt. So make sure you consider the relative importance of their manager duties, how much they're doing of manager duties, and then how free are they from supervision. If they're under direct supervision and they're just bound by policy and procedure, they don't make decisions outside of that, they have to call someone else, they're not going to be exempt. I can almost guarantee you that. So keep in mind those things when you're taking a look at your job descriptions. Okay, so it's important to note that there are some specific exemptions and special provisions, within the FLSA, and each exemption has its own set of requirements and conditions. The exemption criteria can be complicated, and it's advisable, again, to consult with the U.S. Department of Labor's guidelines or seek legal advice to ensure that you're compliant, because this is one of those things you just don't want to mess up. It's very costly. It's going to ding your organization, and this will all be unbudgeted because no one's planning for these things. So definitely get guidance. Don't try to cover things. I can't afford the overtime. Believe me, it's a lot cheaper for your organization to pay that overtime than it is to get hit with a claim. So the exemptions we're going to talk about are executive, administrative, professional. We have outside sales and commissioned inside sales, and then we have computer professionals. So let's talk first about the executive exemptions. This is going to be your C-suite, your CEO, your COO, your CFO. To qualify for this exemption, employees must meet the following criteria. They have to be compensated on a salary basis at a rate not less than the specified threshold for your state, and that's going to be true for all of these. They have to have a primary duty of managing the enterprise or a recognized department or subdivision. Regularly direct the work of at least 2 or more full-time employees, and then have the authority to hire, fire, or make significant recommendations about employment status. Okay, so these are the people at the top. These are the people that are making decisions, setting policy, they're improving processes, they're doing a lot of the selection of the staff and those core executive functions. That will qualify for this exemption. Okay, so the next one is your administrative exemption, and this is the most common one. Okay, so this is where you have office work that's directly related to management policies or the general business operations of your customers. But here's the thing, just because it says administrative doesn't mean that it is an administrative assistant or something like that. This is somebody that has to have discretion and independent judgment. They have to be able to make decisions when someone else is not available or on their own. And it has to be a significant part of their job, not just once in a while. You can't say, oh, I let my secretary make this one decision about one thing one time. That won't qualify. So employees who are functional rather than department heads, they use specialized training, experience, or knowledge. So usually they'll have some sort of degree, and they will be operating in the capacity of some sort of analytical, or they have specific specialized certifications that make them more of a higher level employee than your typical hourly worker.
Nicole, again, sorry to interrupt.
You're not interrupting, please.
Okay, so somebody's saying they have an employee who's team lead but doesn't have decision-making ability, should they be exempt or non-exempt?
If they don't have the ability to make independent decisions and they're working under direct supervision following policy, that sounds a lot like an hourly worker to me.
Okay, and then one other question. What if an employee is back from leave, exempt employee, and their schedule accommodated? Oh, I already did that one.
Yeah.
Sorry.
Well, that sounds familiar.
I'm sorry.
That's
I
okay.
know. Okay.
No problem. Okay,
So
so
if an employee hired mid-pay period or fired and or quit mid-pay period, can their salary be?
it's possible. Consult with your individual state rules. I don't know what state this is coming from, but yes, in certain circumstances, the beginning of a pay period where you're starting or ending employment can be prorated, but that, again, check with your individual state laws and make sure that there's nothing that contradicts that. Okay, so administrative duties. Again, I want to give you some examples of exempt duties. So advising management, that could be somebody that's doing research or analyzing policies and procedures or regulations, or someone that is involved in planning or strategy. So they're helping quarterback an initiative. They're taking a lot of autonomy in doing so. Negotiating deals, so contracts, going to the table and bargaining. For HR, if this is a union environment, that could be an exempt level position. Representing the company, not just going to an event and saying, hey, I'm with such and such organization, but this is actually representing the company in significant decisions, making deals with other companies or negotiating things with vendors and things like that. Someone that has signing authority when purchasing materials and supplies. So this person can commit to financial resources. They could be promoting sales. They could be researching business opportunities, analyzing business data, or determining company or personnel policies. So those would be acceptable. If this person is mostly doing other types of things like typing reports or transcribing, answering phones, those are not going to be exempt level tasks. Okay, so the next exempt classification is the professional exemption. So there's 3 different categories. We'll talk about each one. There's the learned professional, your licensed, and then artistic. So your professional exemptions are not necessarily automatically considered exempt. Again, it is going to go back on to their duties because there's a lot of professional people that are paid hourly. For instance, doctors are paid hourly. Nurses are paid hourly. The only time that nurses or doctors are paid salary is if they have administrative level position doing administrative duties. So just because you have a degree or specialized training, it doesn't matter. It matters what duties are you doing for that employer. So you can't use that as your defense. Well, they've got a master's degree or they've been to, law school. Doesn't matter to the audit. The next one is a learned professional. So this is usually someone with an advanced knowledge degree in science learning. So this could be accounting, engineering, could be medicine, but again, this is going to be someone that is going to be analyzing, interpreting, creating policy, doing that higher level work. And then they also have to meet that minimum salary test. So don't forget that. Your licensed professionals usually hold a valid license or certificate and meet the minimum salary test. So there are certain fields that there are no minimum salary. So law, teachers, some medicine, the rest, they're all going to fall within that minimum salary, twice the minimum wage in your state. But for these three, I would be really cautious and careful. And these would be ones that I would audit. These are ones that I would talk to a professional about and review the job descriptions, and also audit the job description against the work that person's actually doing, because this one gets tricky. And then there is the artistic caveat there too. So this is work in a recognized field of artistic or creative endeavor, and it has to require invention, imagination, originality, or talent. So you've got music, writing, acting, graphic arts, things like that. But again, I pay a lot of graphic artists hourly because it's safer, and they're not doing a majority of it in the creative director role. They're doing things that were directed to them. They're saying, hey, I need a graphic that looks like this and says this. If that's the case, it's probably not going to meet that exemption. So you're giving a lot of autonomy to a creative director who is setting the direction for the creative strategy of the organization, then that would work. Okay, so there is an outside sales exemption, and this one applies to employees who make sales or obtain orders or contracts for services outside the employer's place of business on a frequent and regular basis. So that means more than 51% of time is spent at another consumer's location or prospecting outside in the field. This is not time spent selling virtually. It's not time spent working from home contacting people. This is actually in the doors of their organization. You can't count the time spent on setup, delivery. Those vary between the federal and the state level too. So you have to be really careful there. And this one, there is no minimum salary, but again, you want to make sure that you meet those tests, because if you don't, and they're not in the door of those other businesses 51 or more % of the time, you're not going to make it. Then we have our commission inside sales. So typically inside sales employees earn a significant portion of their compensation through commissions, and then they're classified as exempt from overtime pay under the retail or service establishment exemption. So to qualify for this, certain criteria must be met. Number one, primary duties. The inside sales employee's primary duty must involve making sales or obtaining orders for goods or services, not including retail sales, from clients who will use the purchases in their own business or resell them. They have to have a regular rate of pay. The employee's regular rate of pay must exceed 1.5 times the applicable minimum wage and must be more than half the employee's total earnings in a representative period. So that's usually 1 month, and that must come from commissions. So they have to be receiving those commissions. Then it has to be a retail or a service establishment. The inside sales employee must work for a retail or service establishment that is not primarily engaged in selling goods or services to the general public. This exemption does not apply to inside sales employees working for manufacturing or wholesale companies. And it's important to note that employers must track and record all hours worked by the inside sales employees, including any non-sales related tasks. And if the exemption criteria is not met, the employee is considered non-exempt and entitled to overtime pay, even if they're making a considerable commission. And then we have our computer related exemption. So to qualify for this exemption, employees must meet the following criteria. They must be compensated either on a salary basis or at a high hourly rate, not less than the specified threshold, and have the primary duties that consist of the application of system analysis techniques and procedures, or the design, development, documentation, analysis, creation, testing, or modification of computer systems or programs. So this, just because this is your desk support person, you're not going to meet it. And then you need to be careful with this too, because in certain states, such as California, the salary threshold is a lot higher. It exceeds $100,000 in California right now. So I believe it's close to $115,000. So with my organization that I'm currently with right now, we're paying all of our computer people on an hourly basis because we're not going to meet that threshold in California. So this is not for repair. It's not for manufacturing of hardware. It's not for trainees. It's not for those testing final product software. These are your higher level people doing very complicated analysis, programming, or software engineering work. And again, this was my slide to remember to tell you that California law is a lot stricter. So if you happen to be in California as of January 1, 2023, the computer professional exemption is now at its $112,065.20 or more. So that is almost $9,300 a month, or $53.80 an hour. That's what you have to meet to be exempt from paying them overtime. So
Nicole, we have
yes.
a couple of questions. Can you hear me?
Yes.
So somebody wants to know what the difference exempt, non-exempt, and salaried non-exempt is.
So we're going to go over that salary part of it. The exempt means exempt from overtime under FLSA, and non-exempt means you're hourly eligible for overtime. Your salary are people that may or may not be exempt, but are paid on a salaried basis. So that means that you don't dock them time or anything like that, but they may still get overtime.
Gotcha. Thank you. Thank you.
You're welcome. Okay, so what happens if you misclassify your employees as non-exempt? You leave them as hourly. Nothing happens to you. You're totally fine. So you can pay people hourly. You could pay your CEO hourly if you want to. I don't recommend that because they work a whole lot, but you could, and you'd be safe that way. You're not ever going to get in trouble having your hourly people. But what happens when you misclassify exempt? You could have fines and penalties. You could be held responsible. You'll owe back pay plus interest. You could have settlements. You have legal fees, all the things. So with the employee, they have the upper hand. If they win or you're settling, they have a lot more latitude, because if they're keeping notes about the hours that they work, and you're not requiring them to clock time because you consider them exempt, they're going to have the upper hand, because they're going to have those notes saying, yeah, you know, for the last 52 weeks, you know, I was working 50 hours a week or 60 hours a week, and you're going to be paying them